In MOLLER and Others versus One Touch Solution Limited and Another, His Honour Judge Pearce determined the recoverability of VAT on assessed costs where the receiving party was in creditors' voluntary liquidation. The claim was brought under the Third Parties Rights Against Insurers Act 2010. Following amendment of the particulars of claim, the claimants were ordered to pay the first defendant's costs of amending its defence. At summary assessment, the court assessed those costs at £25,000 net of VAT, reserving the VAT issue for written submissions. The defendants argued that neither the insolvent first defendant nor its insurer could recover VAT, citing Friston on costs. The claimants relied on Regulation 111, subparagraph 5 of the Value Added Tax Regulations, 1995, which permits a deregistered person to reclaim VAT on post-deregistration services attributable to prior taxable supplies. The court accepted this argument, holding that the first defendant's estate could recover VAT via its liquidators. Consequently, no VAT loss had been suffered, and the claimants were not liable for VAT. The claimants were also awarded £1,000 costs of the submissions. Quote, "I accept the proposition, supported by the passage from Friston on costs, that the relevant consideration in determining the recovery of VAT is the ability of the insured party, here the first defendant, rather than the insurer, the second defendant, to recover VAT in respect of the relevant services. However, Regulation 111, subparagraph 5 of the Value Added Tax Regulations 1995 provides clear support for the recovery of VAT by the estate of the first defendant through the liquidators, even if the first defendant itself is no longer registered for VAT. The defendant's assertion that the first defendant cannot recover VAT because of its liquidation flies in the face of this regulation and is unexplained.
For a detailed summary of this decision, visit tmclegal.co.uk.